Welcome to another episode of Seeds of Tomorrow. I am Alessio De Laurentiis, and today we're talking about what really takes to bring a new fruit variety to market, how breeders decide where to invest, what innovation looks like in the field, and why intellectual property protection is central in making those investments possible. I'm delighted to welcome our guest, Alanna Rennie. Alanna, welcome.
Thank you.
She is Chief Legal Officer at Bloomfresh. Alanna sits at the intersection of breeding investment, licensing, and enforcement, at the moment when the sector is dealing with climate pressure, fast-moving markets, and very real infringement risk across borders. And joining me as a co-host, it's Montse. Hello, Montse.
Hello.
Montse García Monco Fuente. She is our head of the legal unit at the CPVO. Before we dive into this question, one quick note. Today's discussion is for insight and understanding on how the system works in practice, not legal advice for any specific situation. I felt I have to add this a disclaimer, having two legal minds with me today. And to set the scene, Bloomfresh has been showing up in the headlines for three kinds of reasons, mostly. Investment in breeding infrastructure, expansion into new geographies like India, and high-profile enforcement outcomes, including China and Italy lately. But let's start broad. Can you tell us what Bloomfresh is and does?
Yeah, so Bloomfresh is a breeder. We invest into breeding new varieties for the benefit of growers, retailers, and consumers. Our breeding program is focused on three crops. So we have table grapes, which is grapes you buy from the supermarket, eating grapes, cherries, and blueberries. We then, once we develop these varieties, we license them all over the world. And if the growers produce fruit that meets our minimum quality standards, we also license to them a trademark, which they may sell the fruit under.
Okay, so from the start, strong licensing model and global testing footprint. And when you look at Europe specifically, what do you see as Bloomfresh's role in the European fruit sector over the next 5 years? Trendsetter, premium niche, platform for year-round supply, or something else?
Yeah, so it's quite interesting in the breeding space. The breeding process takes quite a long time. So we're engaged in traditional breeding, which is crossing and selecting. So it can take up to 10 years to bring a new variety to market.
Mm-hmm.
And I suppose the challenge that we face as a company is we need to work out what the market wants in 10 years' time. So the core focus of our breeding program is on bringing diverse flavor profiles and diverse fruit to consumers, so consumers have more consumer choice.
Mm-hmm.
Within that space, we are developing varieties with different flavor profiles. So you have the candy line, which has more of a caramel or a butterscotch flavor profile. We have more recent varieties, which are mango flavored, mint flavored. And then, of course, breeding for shelf life, firmness, and all the kind of qualities that consumers are desiring. We then are looking at health benefits. So breeding grapes that can bring more or greater health benefits to consumers. And a key product we're working on there is our red berry grapes, which have a red flesh, and by virtue of that have higher levels of anthocyanins. And finally, a core part of our breeding program is focused on disease resistance. And so this has health and sustainability benefits. The disease-resistant varieties will enable growers to grow crops with less pesticides and chemicals, which is obviously then better for human health, but also will have less impact on the environment and will also allow growers to grow more with less, being able to kind of adapt in this challenging environment that we're in. And I think finally, with our cherries and blueberries, we are investing into bringing varieties to the market that can grow in different environments. So varieties that require lower chill levels. And this can combat issues around climate change.
Just touch upon so many subjects I would love to develop more. When a variety is good enough, you approve the trademark for the growers. Am I getting this right?
That's right.
Now you have a double perspective, I may say so, Europe and the world. Where in Europe, what there are the countries that for you are strategic, and what strategic means for you in terms of consumption, because there are ports, there are trade hubs, or because they influence variety adoption trends, as you just mentioned. You are following what the market wants, but you also looking into the future and perhaps also setting the scene for the future, since it takes 10 more years to bring a variety to the table.
Yeah, exactly. So we're branching out now into newer markets. So as you mentioned previously, we're looking at China and India in particular, bringing our existing genetics there and also looking to what these markets may need in the future. And then with our low chill varieties, we're looking at new markets where these potential varieties could grow, where these crops wouldn't traditionally grow.
So you just mentioned India, and I know that Bloom Fresh was present at the India Field Day in February 2026, where you showcased new varieties. In terms of adoption and success, what is the main driver here? The grower economics, the nursery capacity, market pool, harvest performances, quality, quantity, or a combination of all the above?
Yep. Definitely a combination of all of the above and maybe even more. So entering a new market, there's various things we need to consider. You go in the first and you need to do all your modeling, your tax considerations. You need to look at the law and see what level of protection is offered. Particularly in India, they have quite a unique model. So it's not quite UPOV. They have legislation that's called, I believe it's Plant Breeders and Farmers' Rights. So you need to incorporate all of these things at the outset into your licensing model. And then the next step is, of course, nursery. So you can't deliver your varieties unless you have a nursery that you're working with. They understand your protocols, how to produce the plants, and also the various phytosanitary issues with getting plant material into a new market. We then work with growers, so we need to showcase our varieties. We need to get them interested in our program, why our varieties will perform there. And often we showcase our varieties in other jurisdictions where they've been tested and improved. And we can show that in other jurisdictions that may have similar climatic conditions, they have performed like this. And then another aspect in these countries is working out the model. So China and India, you have a lot of very small farmers. And how is it best to communicate and to provide our technical guidance to these small farmers? And often we will try and align ourselves with bigger growers in the market, and we have a program called Train the Trainer. And so the bigger companies who source from smaller growers, we teach them, and then they will flow on the training to the smaller growers.
Your capacity building, you are trying to get everyone on your same protocols, training the trainers, as you just said, and to sort of harmonizing the whole process, abiding to your standards worldwide. If you were to, you mentioned before that I read that you are trying to lead the flavor revolution somewhere in the press, and with the traits like disease resistance, climate resilience, and even the antioxidant that you just mentioned. If you had to reduce Bloom Fresh innovation strategy to 3 drivers, and just these 3, what would be the podium?
It would be health, sustainability, and diversity. So bringing in, as to the last one, bringing kind of more diverse fruit for consumer selection.
Okay, back to Europe now, more precisely in Spain. And this question is linked to infrastructure. I know that in the region of Murcia, you have started building a major breeding and technology center in Blanca, and you expect completion by 2026. Now, very close to home, we ourselves are in the process of moving to our new premises, and so we are building our building. And while we come to understand that there is no perfect plan in the world, and we are experiencing some delays. Is your timeline going to be respected? What will this facility allow you to do that you couldn't do before?
So I think, yes, we're on track. It might be slightly delayed, but very much on track to open our facility this year. And I think the scale of what we're doing is a lot bigger now. So we'll have the resources, the equipment to fast track the breeding process. And then also incorporating into this use of gene technology into the process of traditional breeding, but so you can fasten up the process of crossing and selecting.
Mm-hmm. Since you are going to be in a region that is very dense in terms of knowledge, are you willing, or are you considering to partnership with university growers and distributors across this region to accelerate even more your research?
In terms of research, we are cooperating with many institutes and universities around the world with various projects, not just limited to Spain.
Considering all these aspects, I'd like to circle back to the beginning when you briefly mentioned sustainability and climate pressures. With these policies aiming to reduce pesticide use by 50% by 2030 and our food system facing increasing heat waves, droughts, and extreme weather, how do these environmental pressures practically translate into your breeding priorities? This seems especially relevant since you are installing your research center in an area that is heavily impacted by these exact events.
Well, I think that's the key and the heart of our breeding program, is to develop genetics that can survive in different climatic areas, can withstand changes in environmental conditions, and that we are able to produce more with less, particularly in the context where you have prices of inputs that are increasing, we have pressures on water, and then we have the pressures on the environment from the chemical residue.
Okay, so maybe I can now join the conversation. So hello again, Alanna. It's really very nice to have you here today, and I would like to bring this conversation into, well, starting with something that you said. When Alessio asked you how would you define yourself, the first term that came to you was breeder, and this is a very nice term because indeed now in the breeding sector is really in a moment of transformation with the new genomic techniques. And of course, I cannot but bring this to the discussion because we are now achieving finally what seems to be, we're in the final steps, if I may say, of this new regulation and new genomic techniques. Precisely, you were talking about how important it is for you as breeders also, this development of new varieties with these healthier conditions, these flavor conditions. So all these, of course, new genomic techniques might play a key role in allowing a faster development of these varieties. So now that we are in this impasse from a legislative perspective in which we are what seems to be reaching the end of this, and hopefully we will soon have a regulation. And so from a breeder's perspective, from your perspective as breeder, what would be a good outcome of this regulatory process, both for innovation? So what would be really something that would sustain and promote the innovation in your company, but also for public trust?
Yeah, so definitely you need a system here which balances the interests. And of course, we want to be bringing varieties to the world, to consumers that are healthy and that have been trialed. Our program currently focuses on traditional breeding, crossing and selecting, and we're increasingly using technology to speed up that process. Now, as we're seeing with changes in the EU and also this week, the changes in Peru and elsewhere around the world, there is definitely, we're looking at, as an organization, this field, what's available, and how kind of in the next decade as an organization where we should be, and how we should be deploying new technologies to better bring fruits to consumers and to society in accordance with these regulatory frameworks.
And in following that, would the proposal that now we have on the table, would that be a suitable proposal for you? Would you think that for Bloomfresh, that would be something, I mean, in terms of also, for example, of transparency or the licenses, the patents and so on, would that really be something positive? You would consider that as a positive outcome?
Well, the key thing I think we would like to see as an organization is opening up of being able to do anything in gene technology in Europe. So movement to looking that we could, I think as the baseline, companies could commercialize something that could have been produced through conventional breeding methods. So I think that's really the benchmark for us.
Okay, understand. That's interesting. Okay, maybe changing a bit towards what would be with the CPVR system, because of course the NGT is very much on trend, but of course we are the CPVO, we're managing the CPVR system. And from our perspective, of course, the objective is to have an efficient EU-wide plant variety rights systems that supports innovations and new varieties for society. But when you look at your internal investment decisions in terms of IP, or at least protection of these new varieties that you are developing, that you're breeding, considering not only the budget, but also breeding program horizons or even the markets themselves, what role does the CPVR system plays today?
Mm-hmm. Yeah. So the CPVR regulations are based off UPOV, and to date the development has been governed by what the UPOV convention sets. And just to take a step back and look at it more holistically, the UPOV system was developed with arable seed crops in mind. That's where it came from. And a lot of the concepts in the legislation are focused at seed crops. So farm safe seed, and also kind of the exhaustion concepts. So I think, and the system has developed to also apply to asexually reproduced crops. But I think there are a lot of aspects of the system that haven't really kept pace with these developments. In particular, when you look at fruit crops, and particularly our crops, a lot of the investment and the innovation is focused on the harvested material.
Mm-hmm.
But the UPOV system focuses really on the propagating material and provides an indirect extension of the right to harvested material. So a key thing for us is if we're spending the money and doing everything focused on something that's not directly protected, the system is not fit for purpose. And something that we would really like to see is direct protection for harvested material. This would make enforcement a lot easier and would give us the rights we needed to directly protect our innovation. As a company, and we support Singapore's thoughts on this, we see UPOV as a minimum standard rather than a maximum standard. So we're looking at now that the CPVO is looking to review its legislation, and that's something we would like the CPVO to take into account. And then maybe it could go a bit further in offering particularly protection for asexually crops that is broader and more suited to our needs. So I think that's from the protection standpoint. On the protection standpoint, I think that what the CPVR does great is that it offers quite long protection. So you've got, I think it's 30 years and 25 years, depending on the crop. That's very useful, and that really helps us with a lot of our investment decisions and kind of where to start off, because we have that protection, that long protection in the EU. Some of the shortcomings, though, are the provisional protection and how that has been interpreted by the European Court of Justice. That is kind of, I suppose, it's the double-edged sword. You have the longer protection, but the provisional protection is effectively nothing. And so that is definitely impacting how we see the system. Outside of the law itself, in relation to administration of the registration, as a company, we think we see it as too expensive and too long to get the grant of the right. And this can stifle the business quite a bit, particularly in the context of the lack of provisional protection that is afforded. So we'd really like to see a quicker and cheaper application procedure. In relation to enforcement, now I know this is not the remit of the CPVO, but I understand that the CPVO does have an interest and does explore ways in which breeders could effectively enforce their rights. And of course, this is very important because if we just have a right that you can't enforce, then the right is useless. And it's really difficult in the breeding sector to enforce your rights. Why? Because often our varieties are spread out across very, very remote areas. We don't know where they're growing, so you need to identify infringements. Then we need to try and get some of the material, and we need to conduct DNA testing on it. Then we get to the process of a court case, which can be very long and require a lot of investment. I think systems of enforcement are very important, and how different authorities can work together, utilizing customs enforcement, working with phytosanitary authorities. Phytosanitary authorities often have a lot of information on where varieties are growing. They take samples. So that's really, we see as a good point where breeders can work with to get the material, to test it, and it slides just into a new system that's already working. So yeah, in a nutshell, I think from an enforcement perspective, we would really be interested to work more with the CPVO in awareness and working out how to more effectively enforce the rights that we have.
Okay, that's good because you're just now covering what was supposed to be my last question. If you could have if you could change something of the CPVR system, what would it be? Precisely in line with this evaluation that it's ongoing, and in fact, I hope that you participate in the public consultation that it's open until the 20th of April on the CPVR system. But anyhow, I mean, you have addressed so many topics. They are all very interesting. Maybe some notes from my side, and also to get your feedback, because in fact, you are mentioning the question of the harvested material. It's true that there is this cascade protection, and it's true that the harvested material is subject to stronger conditions. So it's true that it's not the same level of protection. But I don't know if you're following the works at UPOF level, this report that has been that is being discussed on harvested material. I don't know if you are aware of the proposals, and if you have any particular thoughts or consideration on that. Is that would that be something that could somehow? Of course, I mean, UPOF remains UPOF framework. There is no change there, but I don't know if that proposal concerning infringement in outside, so in third countries, that would be something that, from your perspective, would somehow alleviate your concerns.
So I'll reiterate that our strong preference is direct protection of the harvested material. But if we were to step back and look at the current UPOV framework and what it offers, so it provides that protection for the harvested material or the fruit is offered if two preconditions are met. So the first one is that the production of the propagating material was unauthorized. And then the second is that the breeder didn't have a reasonable opportunity to exercise its rights over the propagating material. In relation to the first aspect, that the production of the propagating material was unauthorized, and in the context of like cross-border situations. So I think the first point we look at is, well, how about in those countries which don't offer protection at all? And that's been alluded to in the UPOV papers. So definitely there, we would say, well, you don't have a reasonable opportunity because there's no PBR protection there. But I think you also have a situation where what happens if your PBR has run out in one country, but it still has PBR in the destination country? I would also say in that circumstance that you haven't had a reasonable opportunity to exercise your right, and you should still be able to exercise your opportunity over the harvested material. Otherwise, the protection of the harvested material is futile, and it's not protecting the direct innovations that we're working towards. And in relation to what is a reasonable opportunity,
Yes.
it leaves it very much open to what that means and what a court could interpret that to mean. Many, many years ago, there was a court case in Australia which looked at this in the context of grains, and the court had a good interpretation of the principle. They said, well, your reasonable opportunity to exercise that right is at the time of contracting. So in the contract, the grower, the breeder, could say, well, we exercise the right on the harvested material. These are the conditions and limitations that attach to the harvested material.
Mm-hmm.
And my interpretation is, by virtue of that, if you haven't had the opportunity to contract with the infringer, then you haven't had a reasonable opportunity to put in place your conditions and limitations. I think if we're to stick to what UPOV provides us in this definition, what would be helpful from the CPVO perspective is to maybe elaborate a non-exhaustive list of what would be those reasonable opportunities. And then it's very clear, and we don't need to go to court and argue about what's a reasonable opportunity. We can just point to the CPVO guidance or the regulations and say, well, this is deemed to be a reasonable opportunity or not.
Okay, that's interesting. I didn't know about this court case in Australia, so that's something I'm curious to look into that, because there is, of course, there is not much case law in general, or at least we have a case law database, but it's hard to fill it with relevant cases. So I will look into that. Yes, I take note of this proposal. I mean, there are many proposals, and it's interesting to see exactly what would be also the good points into the term of protection, the shortcomings that you're mentioning for the harvested material, for the provisional protection, and even these aspects of cost and even the duration of the test. So I think this is something that I don't think that you're the only one that are mentioning this. So I hope that this will be finally that they will be addressed in this evaluation that is taking place. But maybe coming to what would be this enforcement, because it's true that you are, as you rightly mentioned, it's not under the remit of the CPVO to deal with enforcement, but it's true that we are also concerned about the effectivity of the titles that we grant, because it is also in order to really ensure that the innovation is fostered and there is a proper system of protection. This system of protection needs to be effective, so it needs to be effectively enforced as well. So it's true that we are engaged in different activities in raising awareness with relevant actors in that area. And then you were mentioning difficulties in how it's in detecting in DNA. So what would be, according to you, so when you are confronted with an enforcement case, because you have had, Bloomfresh has had some cases, very big cases of success, I would say, especially in Italy, in which I recall particularly this case with almost, I think it was 750K of damages, which is really the largest sum that I think that I'm aware of in terms of damages in the PVR world, at least in Europe. So on one hand, there is this aspect of difficulties, but at the same time, you are indeed very active in the enforcement, at least from what I have heard in Italy. So what would work according to you, and what could be done so that it works better? Because also, I don't know if you have different experiences in different countries, because of course, we just from outside, at least we know these success cases that we can see in LinkedIn, in the news, and so on. But then, is it the strategy from your side only to act, for example, in Italy? Are you acting in other countries? Exactly. What works well and what could be improved?
Yeah. So It's the approach in every country is very different because every country, the farming systems, the supply chains are very different. The rules are all different with enforcement. The investigators you can work with are all different. So we develop a unique strategy for each country that we're working in. I think when some of the cases you may see in the press are actually cases that have gone on for a very, very long time. So numerous years, a lot of money, court cases and appeals. It takes a long time. So there's a lot of perseverance there. And we will continue to fight all enforcement when we see it, and to the nth degree, because we owe that duty to our licensees, like the growers who are our partners and who pay the royalties, and to stamp out any illegal activity. The key issues that we face is proving the variety is our variety, which our view is that rely solely on a DNA test. If we can prove through DNA that variety is our variety, then the burden should then flip onto the other party to disprove that in any way they can. But DNA today is very effective, and you can really distinguish the varieties. So I think that's the first one, reliance on DNA. The second one is trying to avoid court procedures where possible. And this is what we're doing a lot of work on, is trying to work with countries, phytosanitary authorities, and other authorities where you can build in an enforcement system within an existing system. So many countries, if they want to export plant material, if they want to export fruit, the grower or the pack house needs to apply for a code. So when they do the checks to issue the code, the phytosanitary authorities will look at diseases. They go and visit the farm. They take samples. They look at the quantity of fruit that's being produced and the quantity that will be exported. And if you can just add into that procedure one further check, which is the fruit PBR protected? And if it is, do you have authorization? And that simple check makes a huge difference. And furthermore, it protects the national industry and the reputation, because I think countries, when you're exporting, they want to maintain that they have fruit that's IP compliant, and they don't want to be exporting and seeing at the destination market the fruit being confiscated at customs. So I think and this comes back into the educational piece, working with countries, national countries, to show why PBR is important. Where there's illegal production, there's often other kind of illegal things or legal rules that the growers or pack houses are jumping, and to create a holistic approach that when looking at other aspects, we're also looking at PBR and whether these growers are authorized, because it's a really important part of the supply chain and to the reputation of the domestic produce industries.
That's thanks for this. It's really interesting, this proposal on the phytosanitary authorities. Maybe two follow-up questions on what you were now just saying, because for me it's good to hear that from your experience the DNA test is very effective. And why I'm saying that is because of also what we have been reported from other breeders or even other actors in this field, is that not all court authorities accept DNA tests, because of course we know that the PBR system is based on the phenotype. So there is an issue in the fact that for some authorities, they for example, they request a DS test to be performed, or at least to complement the DNA, so that at least there is a DNA and then followed by the varieties being grown. And this has brought in some occasions even, this is something that I have been discussing with some lawyers there. They were asking whether it would not be possible to have like a common guidelines on or a common approach on establishment of identity. So I don't know if this is something that you have been confronted yourself. So issues with the potential use of DNA tests, or whether in some countries they might have, or some courts might have put into question the reliability of this test. And in that case, how did you address that? Or if you haven't experienced that, I don't know if that has been the case.
Yeah. So we always work with certified labs in carrying out the DNA testing. And generally, the courts will accept it. However, it will need to be submitted with expert testimony on why the DNA test report is reliable. We often also see a court will request that fruit is taken. So fruit is taken from the infringing material and from the reference sample of our variety and compared side by side to see whether the varieties are the same. That's quite efficient because you can take fruit and compare it. What is long and costly can be if a court orders that plants, a full DUS test is required. So where the two plants are growing side by side and then someone needs to do a morphological assessment. That can take years to do. And that's something we really want to avoid and we think is unnecessary. I don't believe this is in Europe. Countries are requesting this, but we've seen it outside of Europe.
Yes, I'm aware of also in Europe. I mean, some countries, it depends a lot. I mean, the problem is that, that's what I have been reported in any case, that it depends from country to country. And there is a lack of course, it's national procedure. So that might bring also this extra layer of difficulty. But it's good that at least in your experience, you were not confronted with that. So those issues and the DNA tests were accepted. That's at least a positive thing.
Yeah, I think the key issue for us is in certain countries where you need to notarize very complicated evidentiary requirements around gathering the reference sample. For example, in China, the reference sample must come from the actual plant on which the DUS testing was conducted. And this creates all sorts of issues because what happens if that plant dies, or what happens if you want to move that plant to another location? So being able to use reference samples that are not just maybe a reference sample that's with the CPVO would also be helpful. So I think, having clear guidelines as well on what the input material should be for the purpose of DNA testing.
And coming to that, and also linked to the IP forms that you are using, because then you were mentioning these phytosanitary authorities, and if they could check the PBR protection when doing their check, of course, what do you think that, would you see there a role? It should be normally, but what would be for you the role of variety denominations? Now, why I'm saying this, because then you have also understood that you have a strong practice on licenses. And I had the impression, but you might correct me, that it's the license based on trademarks. Is that correct? Or is it the license on the PBR? Anyhow, I've noticed that the trademarks are really, it's a model in which you are also investing a lot.
It's part of our licensing model. So we license PBRs and we license trademarks. The core product we are licensing is the plant breeder's rights. We license trademarks from a quality perspective. So we say, and the retailers will demand the trademarks. So we can say to the retailers, well, when sourcing your fruit, source the fruit that's marketed under this trademark, because we say to our growers that they're only allowed to use that trademark if it meets the quality standards. So it's a way of regulating quality and being able to communicate that to retailers.
Okay, so that makes sense to me. So that's very, very interesting. I'll pass the floor to Alessio.
Slowly but surely, we are reaching out the end of our time together. I really want to thank you for your time and the insights you shared today, especially regarding how you are sowing for the future. As the Breeders' Alliance notes, and as you have corroborated today, breeding can take over 15 years. Looking at your specific categories like table grapes, cherries, and blackberries, what is the single biggest systemic or technological change you want to see 10 years from now when the next generation of varieties come through?
I think direct protection for harvested material.
I was hoping for less use of water, chemical, pesticides, and land.
Oh, okay. Interesting. In relation to law, which we've been speaking about, direct protection for harvested material, and that will enable us to invest more back into our breeding program to develop varieties, I think, that are more sustainable. We try to work on our breeding program throughout the whole supply chain. So we start at the beginning. We want to be able to provide varieties to growers that they can produce more from, that's sustainable, has less impact on the variety, the environment, and in consequences of all of that is thereby healthier for the ultimate consumer. So I think moving forward for Bloom, that's the key driver for us.
Thank you. I usually ask this question to breeders, but I know for a fact that I have two legal minds in front of me today. So I'll ask you this question in line with your job. If you were to speak to a law student today that is interested in IP, what would you say to him or her about where to focus their studies?
Very interesting. Intellectual property is a fascinating area. I was always drawn to plant breeders' rights because I grew up on a farm and my family used PBR protected varieties. And I remember when I was at university and I asked my dad what I should do my master's thesis on, he said to me, do it on plant breeders' rights, because he's like, I've never met a lawyer that understands this area of law. So I think there's more and more work in plant breeders' rights. There's more and more companies investing in this area. And there really isn't a huge amount of lawyers in the world that fully understand and appreciate this area. I think it's a fascinating area. It's in an industry which is developing rapidly in terms of technology and products. And it has this interesting balance of policy, protecting kind of traditional interests, making sure that plant material is available for the world. And then on the flip side, ensuring that companies are motivated to continue to invest into breeding. So yeah, definitely advise getting into plant breeders' rights or IP generally in the agricultural space.
Okay, thank you. Alanna, Montse, thank you both for your time, and thank you to everyone that has tuned up here. This was Seeds of Tomorrow. Thank you.
Thank you.
Thank you.
If you enjoyed this episode, don't forget to subscribe and follow the podcast. Seeds of Tomorrow is a podcast by the Community Plant Variety Office, where innovation takes root. I'm Alessio De Laurentiis, signing out. Thanks for listening, and see you in the next episode.